Mr. Vice Chairman, sir, the Honourable Member has raised a very important issue. And even though the issue has been raised in the context of creation of a bench of the High Court at Surat, the larger ramifications of this issue are of extreme importance to the judicial system. Each state normally has one seat as far as the High Court is concerned. For various reasons, in some of the states, particularly the larger states, more than one seat has been created. The object of creating more than one seat could be many. And one of the obvious criteria is that where distances are very large and litigants have to travel a long distance, and there are regions within a state which are identifiable a little different, then it would be in the interest of justice, in the interest of cheaper justice, that a bench of the High Court can be created at a point other than where the normal seat of the High Court is located. In fact, there are some states where there are more than one seat of the High Court which has been created, and this system itself has functioned well and functioned effectively. The Mumbai High Court, for instance, has a seat in Aurangabad. It also has a special bench in Goa. It has a bench in Nagpur. In Madhya Pradesh, even though the main seat is in Jabalpur, there are special benches created for historical reasons at Indore and Gwalior. Similarly, the principal seat of the High Court in Uttar Pradesh is in Allahabad, but there is a special bench which has been created as far as Lucknow is concerned. The government at present has been functioning with at least two state governments with the object of creating special benches and separate benches in those states. For the High Court of Tamil Nadu, Chennai city has the principal seat of the High Court, but a bench is now being created and all formalities are completed. And we are at the stage where infrastructure is being created for a bench at Madurai. Similarly, in West Bengal, in a very harmonious manner, the High Court, the bar, the state government, the central government have all agreed for a creation of a bench of the West Bengal High Court in addition to the Calcutta bench at Jalpaiguri itself. And this normally helps the litigants, particularly when areas are far-flung, and it helps in cutting down the cost. However, much that there may be a laudable object of creation of these benches, there is a particular legal procedure which has to be followed in the creation of these benches. And the government of the day is at present constrained as far as that legal procedure is concerned. For instance, the Gujrat, in the context of Gujrat, the government of Gujrat had appointed a committee headed by a retired judge of the Supreme Court, Justice Palekar, in 1983 to consider this whole question. Justice Palekar went into this whole question, and on 23rd of August 1985, he submitted a detailed report. Now, I am just giving some of the conclusions that Justice Palekar came to in the context of Gujarat. He concluded that a circuit bench may be established on the initiative of the Chief Justice subject to the Governor's approval under Section 28(3) of the Bombay Reorganization Act 1960. That is, if a circuit bench, which is not a permanent bench, is to be established, the Chief Justice of the High Court is competent with the permission of the Governor to establish that. The central government or no other agency comes into the picture. The Bombay Reorganization Act 1960 does not authorize the establishment of a permanent bench. An amendment of the Act is necessary for such an authorization. But besides that, he further went on to opine, there are no historical, geographical or even sentimental reasons for establishing permanent benches anywhere in the state of Gujarat. Political considerations for establishment of such benches are irrelevant. If due to local pressures, one yields to such demands, from one area also, pressures will build up from other areas and it will be difficult to resist them. In that case, the High Court will be crippled and lose its integrity and cohesion, affecting irretrievably administration of justice in the state. In any event, such an experiment should not be attempted in a new High Court, which is too young to build a strong tradition of an independent and integrity, although currently it is trying to live up to the highest standards. Now, even though in 1983 this report was given and 20 years have passed since then, much water really has flown since then. And the government of India as such is willing to consider whatever suggestions come up before the government of India, because it's also a fact that the population of the states is increasing, the population of the number of cases is increasing, the number of cases pending before various high courts is piling up, the cost of litigation itself is increasing. Therefore, we have always been open as far as the suggestion is concerned. Even though the recommendation of Justice Palekar in July 1991 was then accepted by the state government, but the state government later on in 1996 sought to take a different view, and the Chief Minister of the state in December 1996 requested the Chief Justice of the state, as also the Chief Justice of India, to look into the issue of creation of a separate bench in Gujrat, in particular at places such as Rajkot and Surat. There have also been some demands which have come from the city of Baroda for the establishment of a bench in the city of Baroda. The Chief Justice of the High Court had intimated in May 1998 that it was not possible for them to accept the proposal of a circuit bench or a permanent bench. The state government again took up the issue when they wrote to me in September 2000 that I should take up the matter again with the High Court for the creation of a separate bench. Now, in between, an important development has taken place, and that is the development which Sri Lalitbhai Mehta referred to. There have been, particularly in two states in the context of Western UP, though there is a conflict of opinion whether the bench should be within Western UP, also there is a conflict of opinion whether the bench should be at Meerut or at Agra. But there has been a strong demand by the advocates and the litigating public of Western UP that they need a bench there, because from some parts of Western UP, it is almost 400 to 500 kilometers is the distance to either Lucknow or to Allahabad. Similarly, as far as Karnataka is concerned, there is still a difference. In Uttar Pradesh, there is still a divided opinion within the whole state, even though there is a strong opinion in Western UP.
And
but
Madhya Pradesh?
Well, Madhya Pradesh is a category apart, because in Madhya Pradesh, I may be indiscreet and say this, when the capital was chosen as Bhopal, it seemed to be an arrangement at that time that the capital would be Bhopal and the seat of the High Court would be Jabalpur. And that is how the two interests of the two different regions of the state, Mahakaushal and Bhopal region, were accommodated. Subsequently, benches were established at Indore, which was the commercial center, and also in Gwalior, which was a long distance from Jabalpur. So Madhya Pradesh already has 3 existing benches, in addition to the principal bench. And after the carving out of the state of Chhattisgarh in Bilaspur, a similar arrangement was reached, that the capital of the state is Raipur and the bench of the High Court is at Bilaspur. Therefore, in what was originally Madhya Pradesh, you have Jabalpur,
Gwalior.
ये
मध्य प्रदेश का जिक्र किया और वो मेहरबानी करके हील किए हैं।
भोपाल में मेरा भी इंटरेस्ट था।
जी मैम, आपका संरक्षण चाहिए। मध्य प्रदेश एक ऐसा प्रदेश है मैम जहाँ की राजधानी में हाईकोर्ट बेंच की स्थापना नहीं हो पाई है। पहले की स्थितियाँ कुछ अलग थीं, अब परिस्थितियाँ बदली हुई हैं और कई बार यह मांग आई है कि मध्य प्रदेश की राजधानी भोपाल में एडमिनिस्ट्रेटिव दृष्टि से, मैं बहुत विस्तार से नहीं कहना चाहूँगा, जब एडमिनिस्ट्रेटिव दृष्टि से वहाँ पर हाईकोर्ट बेंच की स्थापना की जाए, और नहीं तो वैकल्पिक दृष्टि से जब तक हाईकोर्ट की बेंच की स्थापना की प्रक्रिया प्रारंभ हो, तत्काल वहाँ सर्किट बेंच की स्थापना कर दी जाए। यदि माननीय मंत्री जी इस विषय में कुछ प्रकाश डालेंगे तो बड़ी कृपा रहेगी। इसी सदन में माननीय प्रधानमंत्री जी के हस्तक्षेप से यह बात कही गई थी कि मध्य प्रदेश की राजधानी भोपाल में हाईकोर्ट की बेंच की स्थापना करने पर विचार किया जाना संभव है। यदि वो इस दिशा में विचार करेंगे तो बड़ी कृपा होगी। धन्यवाद।
भोपाल का समर्थन करते हुए मैं माननीय मंत्री जी से निवेदन करना चाहूँगा कि इसी तरीके की प्रॉब्लम उत्तरांचल में भी उठ रही है और हरिद्वार का केस बड़ा स्ट्रॉन्ग है। यदि आप सर्किट बेंच की स्थापना के विषय में सोच रहे हो तो हरिद्वार पर विचार जरूर करें।
I am happy that there are not many members in the house.
हरी जी,
मैडम, ये आपके लिए भोपाल का केस इग्नोर करना तब भी सरल है, हरिद्वार का केस इग्नोर नहीं कर सकते हैं।
Madam, out of these issues which have come up, there are several important questions which arise, and I'd like honorable members to consider some of them. Suresh ji said the case of Bhopal is extremely important because Bhopal is a capital city and it's one of the few capital. In fact, I may remind him that Trivandrum is another capital which is without a high court. Bhubaneswar is another capital which is without a high court, because when the states have been created, perhaps at that time one of the administrative plannings would have been keeping various regional interests of the state in mind, that you have the capital in one state, and in some of the states you can have the seat of the high court in other states, therefore you can satisfy various interests. This is perhaps what must have happened in the context of Madhya Pradesh. In Uttaranchal Pradesh, I was associated at that time with the creation of the high court in Uttaranchal, and I can say for certainty that one of the important considerations that prevailed upon all those people who were taking the decision, and this was cutting across party lines, that when the capital of Uttaranchal was being created in one city, the interest of the hill regions also was a very important consideration, and it was one of those reasons, and particularly when we had the old secretariat left by the British government for the United Provinces in a very beautiful building available in Nainital, it was decided to have the bench of the High Court in Nainital. I had said this earlier when the Rajkot matter came up, and I'm sure Ravaji would appreciate this, what I'm saying, that when I had gone for the purpose of creation of the High Court at the time of inauguration in Nainital, there was jubilation in the city. Subsequently, and these are various considerations which I'm not saying that was a wrong decision by us. Subsequently, a lot of people, when I went on repeated visits, they said, well, Nainital has made litigation costlier for us, because the cost of a litigant coming from different parts of the state into a hill town, it takes several hours before you reach there. When you go to Nainital, you have to stay in a hotel. Being a hill station, the hotels are far more costly for the litigant than they would be in other parts of the place. But these are all accommodations because of the various considerations which had come up, which were made at that stage. Now today, I would only urge members that it has to be cautious of one weakness which we all have a tendency to fall into, particularly keeping the background of whatever city we come from. The considerations are, and the considerations have to be, how much is the distance that a litigant would have to travel from different parts of the state to reach the High Court? What are the facilities available there? What is the center of litigation as far as the states are concerned? These are several considerations that have to be followed. But at times, if we start demanding a High Court in every alternative city, then perhaps we start weakening the very cause of having benches, because an alternative thought process goes in, that well, it is on account of, and that is what the comment of Justice Palekar that I read in the context of Gujrat, where he said, I'll reread it, political considerations for establishment of such benches are irrelevant. That you merely can't say that just because somebody comes from a particular city, therefore it is customary for him to espouse the cause of that particular city for a bench. And therefore what needs to be done is that this has to be dispassionately considered. And I must say, in the context of the two states where decisions have been taken to create benches, that is West Bengal and Tamil Nadu, the process has been discussed between the judiciary of those states, the members of the bar of those states, the state governments, and all others, including the politicians of that state, in a very dispassionate manner, and we were able to take decisions without any significant controversy. In West Bengal, the only small controversy was whether it should be Siliguri or Jalpaiguri, which are towns in close proximity to each other, but everybody conceded that for North Bengal people to come down to Calcutta for a case was extremely difficult. What unfortunately appears to have happened is that while interpreting the State Reorganization Act in the context of Karnataka, and the context of Karnataka was very relevant, because in Karnataka it was one of the states where the state assembly had passed a unanimous resolution for the creation of a bench in North Bengal. So there was unanimity in the state. All political parties were in agreement. The bar was also in agreement, because the Bangalore lawyers would not be affected if a bench was created in North. Those belonging to the North perhaps may have shifted there. But in that case, somebody moved the Supreme Court. And the Supreme Court, while interpreting the provisions of that Reorganization Act, gave the following observation, and I'm reading this. And this has really created a lot of difficulty for us to dispassionately consider this whole issue. The High Court is that best suited machinery to decide whether it is necessary and feasible to have a bench outside the principal seat of the High Court. If the High Court does not favor such an establishment, it is pernicious to dissect a High Court into two different regions on the ground of political or other considerations. So it is out of question to decide for the establishment of a bench outside the principal seat of a High Court, contrary to the opinion of the Chief Justice of that High Court, which has been formed after considering the views of the colleague judges. Now the effect of this is that Article 130 which Sri Lalitbhai Mehta read out, in the context of Supreme Court says that the Supreme Court will sit at New Delhi or at such places that the Supreme Court will decide. So even when the constitutional framers thought that it may be possible for Supreme Court to sit at places other than Delhi, and we for strongly, the government believes, the standing committee has opined this, that there is a strong case for even having a bench of the Supreme Court somewhere in south and certainly somewhere in the east. Because for northeast people also to come down for every case with litigation becoming so costlier is extremely difficult. Unlike Article 130, with regard to the High Courts, we have to go to the provisions either of the Special Reorganization Act or Section 53 of the State Reorganization Act. Whereas under Article 130, the primary jurisdiction on reading the constitutional article was of the Chief Justice. In the context of the High Courts, it is vested with the central government. But by an interpretative process, just as the power of judicial appointments which vested in the President has now de facto shifted to the judicial institution, the administrative power to decide whether a bench should exist or not, which under Section 53 of the State Reorganization Act vested in the government by virtue of this observation, also seems to have moved in favor of the judiciary.
Mr. Minister, you have agreed that we have a very strong case.
Yes, there is a...
This comes in a way, then why don't you come forward and use this forum
Now,
by amending the Section 28(3)?
Now, Madam, we have been therefore forwarding all the requests which have been coming from different states as to the High Courts for their opinion. As I mentioned, 2 High Courts have expressed their opinion in the context of West Bengal and Tamil Nadu and have agreed with the object of creation of these benches. The government, on all requests which come to us, is in a consultative process. Now there is a judgment of the Supreme Court which has come. We have also taken the views of the Attorney General with regard to this particular judgment. I don't want to go into those details. But one fact I may say at the cost of repetition, which I will request Lalitbhai Mehta also, that even when demands are raised, at times we are going to weaken our case if we go in for an overkill in the matter of demanding a bench almost in every alternative district. For instance, if you say that you need a bench in Rajkot, you need a bench in Surat and you need a bench in Baroda, and there is a need for a bench in all the 3 places in a state, please let me...
recommended only 2 places.
Therefore, if...
You very well know.
He is hypothetically asking.
if you start saying you need it in all the 3 cases, then perhaps for all 3 places you are going to weaken your case. Therefore, in such cases, we also, the state governments, the members of parliament, the members of the bar who demand this, will have to be very objective that in accordance with those 21 criteria which have been suggested by the Justice Jaswant Singh committee, that the demands must really come within the parameter of that. Today, Madam, as the situation stands, we have an observation of the Supreme Court, which I referred to on an earlier occasion when the Rajkot bench question also came up, which stands in the way of government taking any particular decision. If any request comes, as the law stands today, the complete proposal can only come if it comes from the state government. We send it to the High Court. The High Court has to recommend that proposal. It's only after the High Court recommends the proposal that it becomes a complete proposal for our consideration of the central government. As such, there is no complete proposal before us as far as the bench at Surat today is concerned. And I would therefore urge the honourable member to request the state government to once again start work for an alternative complete proposal, move the High Court with the entire case in favor of whichever city that they desire, and till that happens, for this house to then pass a legislation or accept a legislation for the government to accept this may perhaps be a little difficult. I urge the honourable member that in view of the fact that the government in principle supports the idea of having benches only at such places where it is reasonable and necessary to have benches, and I would therefore urge the honourable member to kindly consider withdrawing her private member's legislation.
Thank you.